Seated. We are back on the record in the case of People versus Davion Thompson. The record should reflect the jury is not present at this time. Mr. Fedork, will you be using the monitor anymore this afternoon?
The monitor as in the screen up here?
This monitor.
Oh, I will not be playing any video.
Okay, then we need to move that out of the juror's way so they can see, and I can see them. Anything else for the record, Mr. Fedork?
No, Your Honor.
Mr. O'Farrell.
Your Honor, I did notice outside, I'm guessing about a half a dozen young people carrying signs, which I didn't pay any attention to. I thought they were maybe Black Lives Matter or something. They were in the vicinity of where the jury was told to park, and I parked in that same area. I was advised by deputies that in fact the signs referred to my client, something to the effect of free Davion, to that effect. I wanted to bring it to the court's attention, and now they're gone, Judge. I've been talking to deputies again. I'm not sure how long they were out there. They also seem to roam up the street, so I don't know if any jurors actually saw them. I wanted to bring it to the court's attention with maybe a suggestion that they should be asked if they did observe any pickets without going into what they said, and if they did, then just tell them to ignore it or something like that, or maybe not bring it up at all.
My inclination is not to bring up at all, Mr. O'Farrell. I guess they can see signs on I-675 anywhere. So for me to try to control what they do or don't see from someone who is not part of this trial, that's a slope I don't intend to slip down.
The only concern I have, Judge, is if a person might tend to attribute it to my client, and we had nothing to do with it.
The converse could be they could take it into consideration and say, yep, we're going to free Damien. So they could cut both ways, Mr. O'Farrell. So I figure I'll leave it alone.
I understand the court's ruling.
Okay. Anything else, Mr. O'Farrell?
No.
All right, we can bring the jury back in. Deputy Detective Jacobs, you can still take the stand. Please be seated. Mr. Fedork, you may continue your questioning, and Sergeant Jacobs, you're still on oath for the purpose of this testimony.
Yes, sir. Thank you, Your Honor. Sergeant, was there some ballistics evidence that you did something with?
Yes.
Okay, so there were a number of casings, bullets that were found and entered into evidence at the department, correct?
Yes.
Okay. And was there anything in particular you did with those items?
Some of those items were sent to the Michigan State Crime Lab in Bridgeport for analysis.
Okay. Now, first of all, items that were, I guess, collected at the scene, the 522 South Bond address, was there something there that you sent to the lab?
Yes, there was evidence collected at the scene that was sent to the lab. Yes, I do.
And what is it?
It's an evidence package created by MSP Detective Satora, badge 460, listed as a PMC 40 S&W Gold FCC, and in parentheses, there's a 3, which indicates there's 3 of them in there.
Okay. And were those casings that were collected by Detective Satura?
Correct, on 127 of 18, and the listed address is 522 South Bond Street.
Okay. And what did you do with those?
Those were sent to the lab, the crime lab in Bridgeport for analysis.
And the people moved to admit Exhibit 20.
Mr. O'Farrell.
No objection, Judge.
Exhibit 20 will be admitted.
And did you receive those back from the lab after they were sent there?
They were returned to the Saginaw Police Department and logged into the proper room.
Now I'm handing you People's Exhibit 20, 26, 27, 27.
Do you know what those items are?
I do.
What are they?
These are items that I seized at the autopsy of our victim, Mr. Parham.
And what were those items specifically?
Number 26. I can identify this through my case number along with my name. I logged it into our evidence room on 129 of 18, which would have been the day of the autopsy. The autopsy took place at 1447 North Harrison Street, which is going to be the Covenant Harrison campus. At that time, that's where the Saginaw County Morgue was located, and they were recovered within the autopsy room. In this package here, in number 26, I have one spent / mangled bullet recovered from the victim's right upper arm by Dr. Barani during autopsy. After Dr. Barani located it and removed it from the victim's body, it was turned over to myself. And once I left the autopsy, I returned to our department and logged it into our evidence room.
And were those sent anywhere from the evidence room?
Yes, this piece also went to the Michigan State Crime Lab for analysis.
And then did it get returned back to the department from the lab?
Yes, it did.
And that was after testing, correct?
Correct.
People moved to admit 26, 27, and 28.
Mr. O'Farrell.
No objection, Judge.
Exhibits 26, 27, and 25 will be admitted.
I'm sorry, but I had 26, 27, and 28, Judge. Am I wrong?
And you're all correct, the record. I apologize, that was my mistake. People's exhibits 26, 27, and 28 are the items that Sergeant Jacobs just referred to.
26, 27, and 28. Those will be admitted.
Thank you. Sergeant, I place in front of you people's exhibits 21, 22, 23, 24, and 25. Do you recognize those?
I do.
And what are they?
They are all heat sealed pieces of evidence that at time Officer Wenger seized from the victim and logged them into our property room as evidence.
And did they go anywhere from your evidence room?
To the state crime lab, once again, for analysis.
And I believe it was just 3 of those exhibits, is that correct, that went to the lab?
Correct.
And could you just indicate which three by number?
25, 24, and 23.
Thank you. People would offer into evidence exhibits 21, 22, 23, 24, and 25.
Mr. O'Farrell.
No objection, Your Honor.
Exhibits 21 through 25 will be admitted.
And obviously, Sergeant, those exhibits were returned, or that evidence was returned back to the department.
Correct.
And so all those items I just went over as far as the ballistics evidence, that was all tested for what purpose?
Some of it was for comparison. I believe some of it's going to be for actual identification of partial bullets, as far as what potential caliber they were. Some spent bullets may have enough, what would be called rifling on the bullet itself, which is a characteristic left as the projectile goes through the barrel. Inside of a handgun, you have rifling, which gives the bullet spin, which makes it a lot more accurate when it does come out of the firearm. And I can't say every single time, but I would imagine the vast majority of the time, there are these markings left on the spent bullet as it exits the firearm barrel from the barreling of the inside, or the rifling, I should say, inside the barrel.
And that analysis was done at the lab.
That would have been done at the lab, yes.
And then finally, there were some cell phone records that you obtained a warrant for, correct?
Correct.
And what were the cell phone records for?
Investigative purposes to analyze the information that would have been inside the cell phones.
You obtained some cell phone numbers of the defendant and then witness Lisa Curtis, correct?
Correct.
Okay.
Objection, Your Honor. Again, there's the assumption of my client's telephone number. It's the number associated with my client. That's what the evidence is.
That's fine, Your Honor. I can rephrase my question.
All right, rephrase your question.
So, Sergeant, you obtained a phone number, 989-475-4365, that you've previously testified that's associated with the defendant, correct?
Correct.
All right, and then also Ms. Curtis's phone number. So based on those phone numbers, did you seek a warrant for their records?
I did.
And after obtaining those warrants, what did you do?
I received them via email, and then I ended up forwarding them to MSP. I believe he's, I'm not sure what rank he is, but it's Randy Kahn.
All right. So you received the cell phone records from the cell phone provider companies, correct?
Correct.
Okay. And then they were forwarded on to Detective Kahn.
Detective Kahn for analysis on his end.
Okay, thank you. People would move to or offer into evidence would have been marked as 111 and 112.
Mr. O'Farrell.
No objection, Judge.
Exhibits 111 and 112 will also be admitted.
And moving on from that, Sergeant, I want to go back to the defendant's interview, as well as the text messages that were introduced earlier in your testimony. When, as lead detective in this particular case, when you were analyzing the case, were you able to find any consistencies in the defendant's interview and the substance of those messages?
I did.
And what was that?
In the initial interview with the defendant, he had made mention that the texting going on back and forth in regards to he and the victim getting together in Bloomfield to smoke marijuana, that when that conversation ended, that was the last contact that he had had with the victim, basically forever, because the victim is deceased now. The text messaging does not show that. It shows that he had contact with them the following day, which would have been on the 22nd. During that conversation, it can be shown that the victim hits him up and asks him what happened last night in regards to the defendant not showing up to smoke marijuana together. Which obviously, if we go off of the defendant's interview initially, he said that he only had contact with him that day, which was the initial day where they were going to make their plan to set up to smoke weed together. And he claims that that was the last time that he had contact with him, but the records show otherwise.
So the defendant's statement, as far as the last time he had had contact with Mr. Parham, that matched up with the texting from January 21st, 2018, is that correct?
The 21st would have been that text information, as you read it, is very consistent with the description that the defendant gave myself and Detective Wortley during the day of the interview in regards to the information that he and the victim were going to smoke marijuana together in Bloomfield.
Okay. Were there any terms used, terminology, I guess, is what I'll put it, in the defendant's interview that you can find a consistency with that interview and the text messaging substance?
He referred that they were going to smoke weed together during the interview. And during the text, there was other street slang such as blow, gas, made reference to getting some relos, which I know from experience in policing that subjects will get cigars or Black and Milds or relos, and they will cut them open and they will insert marijuana mixed in with the tobacco, reseal the wrap, and then smoke it up that way. And that's referred to a blunt. And that term was also used during the texting.
Okay, thank you. That's all I have, Your Honor. Thank you.
Questions, Mr. O'Farrell?
Thank you, Your Honor. I don't want to be argumentative, but turning to the last line of questioning about your opinion of the interview disclosures of my client, Mr. Thompson, and then what was in the text messages. In the text messages, you indicated to the jury that there was one day that my client said that he had talked to the person
In the text messages or in the interview?
in the interview.
Yes.
Didn't he also say that he had talked to him on both the 16th and 17th?
I think it was the 16th or the 17th. But obviously that date wasn't correct either because these messages came
Right.
through on the 21st and 22nd.
Right. So if he mentioned the 16th and 17th, he had 2 days, but he had the wrong 2 dates. Would that be correct?
I guess.
Okay.
I don't know.
And as he described those text messages, I believe he said that Tone had kind of contacted him out of the blue,
Correct.
okay, and that they had discussed marijuana.
Yes.
And although he used the term marijuana with you, you're familiar with street slangs for marijuana, right?
Correct.
And you referred to those street slangs in the text.
Yes.
And those are known to you as slangs.
Correct.
They're known to virtually every smoker of marijuana. Am I exaggerating?
I guess I can't speak for every marijuana user, but
I can't
I know
either.
this.
I mean, they're common,
They're
right?
common street terms, yes.
All right. And in my client said, Mr. Thompson, that he had lied, or that's the word that you used, by saying he was going to meet up with the guy and then he never did. You remember that part of it?
Of the interview,
Interview.
I think he used the word that he lies to people.
Okay, all right, and maybe you're right. At any rate, one of the first questions asked on the second day by Tone was, how come you didn't show up, or where were you, right?
Correct.
So that was entirely consistent with as it was described, is that true?
In regards to,
The lying about showing up and then not showing up?
yes, that's what he told me that he did.
Okay. And then there's reference to Bloomy or Bloomfield, is that correct?
Yes, that's a neighborhood down in the southeast side of Saginaw.
Okay. And apparently, and I guess I'm interpreting it, and asking you to, Tone was saying he was going back and forth between Bloomfield and the west side.
Correct.
Okay. And my client said that that was the last time he had communicated with Tone, is that correct?
Would have been that first initial contact.
Or the second, if it wasn't the word or, it was both. If he said the 16th and 17th, if he used the word and instead of or, it would have been both communications. Correct?
If it would have been, you're using the word and, am I hearing you correctly?
Yes.
Your Honor, I think, I'm going to object. I think Sergeant already answered the question as in the interview, it was the 16th or the 17th. So I'm not sure why we're getting into a hypothetical.
It's not a hypothetical because the jury heard the tape, Judge. I'll just leave it to the jury. I'll withdraw the question.
I don't think it's up to Mr. O'Farrell to determine.
He's
what the
already
jury heard.
withdrawn the question, Mr. Fedoric.
Now, may I approach a witness, Your Honor?
You may.
Detective, we've had admitted Exhibit 1 concerning the phone messages or the messages that were obtained from Lisa and provided to the police. You're familiar with those, correct?
I'd have to see them.
You're familiar with it?
Well, as I stated in previous hearing, this would have been, I guess, now the second time that I'd ever seen these.
You've been the lead investigator in the homicide of Antonio Parham, correct?
Yep, this was information in regards to a different homicide. Not this homicide. That's why it was sent to either Detective Bush or Worley, because they were working that case.
Okay. You heard the testimony of Lisa Curtis concerning those messages, did you not?
I did.
You were present for that.
Yes, sir.
Do you recall Lisa confirming that she had advised the police that both she and Tubbs were cut off by Tone?
Objection. Is that a question of whether the sergeant recalls that in the testimony?
Yes. I thought that was the question.
I thought that was the question too.
And I guess that's up to the jury to determine what the testimony is. I'm not sure why that's being asked of the sergeant.
Overrule the objection.
Could you repeat the question?
You recall Lisa testifying that she and Tubbs had been cut off?
Cut off from what?
from Facebook by Tone?
Yes.
Okay. And Tone had become aware of them? That was the reason he cut them off? Look at page 3 if you need to, or
Okay.
if you recall the testimony.
That I don't remember hearing that, but I'll take a look at page 3.
I'm sorry, it's over on 4.
4? Okay. Says he blocked us a couple days ago.
Okay. Well, it's in his page, in his about info, but Tubbs nor I can get to his page. He blocked us a couple days ago since he found out that we heard.
That must be on a different page because that's not what I read.
Oh, I'm sorry. Well, these aren't paginated, so I apologize. And it's doubled. There's
Yeah, I
2
don't have-
pages.
This doesn't have anything resembling that whatsoever. Unless I'm missing it, but
You may.
they say you blocked us. Nothing about cutting us off. Right. You're using the word cut off. Yeah, that's why I was confused because I'm going off of your verbiage and I didn't see any of that in here.
So I used the word, so what the quote says, well, read the quote.
You want me to read the
Yes,
first bubble?
yes.
Okay. Well, it's in his page, in his about info, but Tubbs nor I can go to his page. He blocked us a couple days ago since he found out that we heard.
Do you know when this communication was sent to the police?
I don't.
In your interview with Davion, he gave you a phone number, didn't he?
He did. I believe he gave it to Detective Worley, which was passed on to me because I think at that point I had stepped out of the room when we were getting some basic info to begin with.
Okay. Do you know what that phone number was?
I think it started with 443, but the remaining numbers, I would have to look at my report.
Do you have access to your report?
I need my binder. It's in there. No, that's. Mark, just grab me my binder. I know right where it's at. It's just a matter of, it's on the box. Nine eight nine 443 3029.
Okay. And the number that we associate with him as far as the phone of Brandon Pennywell is the 465 number that you've related the communications, is that correct?
989 475 4365.
Yes.
Correct.
So he had a different phone when you interviewed him on the 30th?
That's the phone number he gave, yes.
Did you do any investigation to see if that was his phone?
No.
Did you do any investigation as to confirm that whether he had lost his phone?
As far as,
The hospital, doctor's office, anywhere else?
no,
Did you hear the testimony of Lisa Curtis that Tubbs knew where Tone lived?
yes,
That was her testimony to this jury, wasn't it?
correct.
But in that last messaging that you have the texts from, that was on the day of the homicide, wasn't it? The 27th.
Yes,
And it leads right up to the time of the shooting, basically.
correct.
And it's giving directions, and you can almost sense the two people coming together and what's going to happen.
In the text messaging,
Yes.
yeah, they're getting ready to meet up.
And the person who was on the phone at that time, that's when they found out where he lived, right?
When he gave an address,
Yes.
yes,
Which they needed to find him, right? That's what they were asking for.
yeah, they need to know where to meet.
Okay. So the person who was on the phone doing the shooting apparently didn't know where he lived.
Well, and not until that moment, I can
Okay.
only attest to the text information.
Okay. But again, Lisa Curtis testified, told this jury that Tubbs knew beforehand where he lived.
Yes,
You described to the jury one of your first tasks at the scene was walking all the way down Porter Street to Gratiot to see if there were any surveillance cameras or anything, right?
correct.
Then when you interviewed Davion, you told them that there was cameras and witnesses that said that they identified him as being the driver, right?
Yes,
So you lied to him?
yes,
Okay. That's part of your techniques in interrogating people, is that right?
correct.
One way to, I'll use the word intimidate, but perhaps influence, whatever word we want. But to get somebody to confess is to make them think you already know or you know more than what you do. Is that right?
To get somebody to confess to a crime that they did commit, yes.
And in this instance, of course, all Davion showed was confusion. He never confessed, did he?
Never made a confession.
You investigated the Dodge, well, yeah, the Dodge Charger. You got a search warrant and you did the search on that vehicle, is that right?
Correct.
The crime lab has individuals who do detailed searches of vehicles, don't they? Have you ever sent cars to the crime lab to be searched?
I never have.
Okay. Did you check for fingerprints?
No,
Did you take any swabs for DNA evidence?
didn't need to,
Because you had already decided who you thought did it?
because he already admitted to being in the vehicle.
Okay. So right now, my car is sitting out on the street. You would expect to find my prints in it, correct?
Yes,
But if somebody stole my car, you wouldn't check for fingerprints to try to see their prints as opposed to mine?
of course we would.
Okay. So in the canvas of the neighborhood, and you mentioned the young lady who gave the description of a male driver with a mask.
Black male, light skin, hoodie, and a light, or when I talked to her, it was a,
Excuse me, her testimony was a yellow mask?
correct.
You had no eyewitnesses who identified the driver, is that correct?
Correct.
The car was located by the Saginaw Township Police at 1:18 in the same afternoon, according to Officer Hill, is that correct?
Yes.
You have no reason to doubt the truthfulness, do you?
No.
The shooting happened at what time?
Approximately 12:30.
So about inside of an hour, the vehicle is located.
Correct.
The engine is still warm.
Yes.
There's a smell of marijuana in the engine or associated with the vehicle.
Correct.
When you searched the vehicle, was there still a sense of a smell of marijuana?
Not that I can recall.
Would you agree that there's a distinction between smoked marijuana and raw marijuana?
Yes, there is.
Now, you heard testimony that the shooter was in that Charger and that the victim was standing outside. Is that correct?
Yes.
Did you check for any gunshot residue or do any examination?
No.
Is that because that's too expensive?
One of a few reasons.
You referred to your search at Davion's house, locating some items in the basement. Is that correct?
Yes, I located one item.
Was that his ID?
Correct.
Did you have, did the basement appear to be occupied? Was there clothing and stuff?
There was clothing. It was pretty disarray. Looked more storagey than anything, I guess, but somebody could have been living in there.
Okay. Did you take custody of the clothing that was seized upstairs?
Clothing seized upstairs
Yeah.
in the house?
Yeah.
No.
Detective Giroux testified about a search and finding a bullet fragment
Correct.
associated with some clothes on the floor.
I think he said that there was clothing sprawled out throughout the bedroom, and he located the, I guess, fragmented bullet in it.
Was that bullet seized?
Yes.
Was it examined by the state police?
I'd have to take a look at the evidence to let you know one way or the other. I believe it was sent. I think that was part of the packet that Mr. Fedor originally had me testify to.
Okay. So that clothing was never checked to see if there was any gunpowder residue on it or anything, correct?
No.
It wasn't even checked to see if it would have fit Davion or could possibly have been his clothing, was it?
Nope.
when you questioned Davion in interviewing him, he indicated to you he had been sick for several days. Is that correct?
Yes,
Indicated to you he had been in the hospital?
he went to Covenant, yes.
And do you know when he was in Covenant Hospital?
I believe it was the Thursday prior to this incident.
Okay, this incident happened on the 27th, is that correct?
Yes,
About 12:30 or so in the afternoon?
correct.
If Dr. Bishop, you were here when Dr. Bishop testified.
Correct.
If she testified he was admitted at 10:48 on the 25th, and then released at 2:26 in the morning on the 26th. Does that refresh your memory?
Yes,
We saw, strike that. I want to go back to Exhibit 1, if I may.
This
On-
one, the text messages stuff?
Yes.
Okay.
On the same page where we had our trouble about being blocked for a couple of days.
Okay.
Down below that, you recall Lisa testifying about that she forwarded the communications that she had gotten from from Jamel?
Yes,
And that was, I paid 3 clucks, they all gave me the same name, correct?
yes.
What's a cluck?
Kind of a street slang term for a drug user, kind of the same term as like a crackhead.
Well, isn't cluck associated with someone who lets someone use their car as part of the consideration so they can get drugs?
Well, that would be something different.
That's something different?
That would be like a cluck car,
Okay,
yes.
so clucks don't drive cluck cars?
It becomes street slang when the vehicle that a drug user slash cluck slash crackhead, however you want to use the term as, it becomes a cluck car when it's traded for drugs.
Okay. Okay. Now, Davion told you that he had gotten permission from Lisa to use her car so he could go to the interview on Monday at Jimmy John's, right?
Yes,
And he told you he picked it up on the south side,
yes,
gave you an address in the area of Grant and Douglas Street.
yes, but I told him that those streets run the same direction.
Right. But you're familiar with the neighborhood.
I am,
And is that a neighborhood associated with, that you're familiar with from law enforcement?
associated with,
Well, I mean, that you were once lived there or something. It's significant to law enforcement, isn't it?
yes,
It's what would police commonly call a high crime area,
high crime area, yes,
high drug use area.
yes,
And then he said he dropped it off at the same spot, right?
correct.
You heard Lisa testify that she was taking medications or pills that were not prescribed for her, is that right?
Yes,
She testified, she told the jury about that, true?
correct.
And those medications were Vicodin, Norco, Percocet, and Adderall. Is that correct?
I can't remember the exact ones, but I would think that that would be accurate.
And do you know if those are brand names for hydroxycodone and Oxycontin?
Objection, Your Honor, relevance.
It's the relevance, Mr. O'Farrell.
Well, I believe, Your Honor, I can establish that those are opioids and that she was using those on a non-prescription basis at the time, which would be consistent with her having left her car as a club car in the South End.
I think that's a bit of a stretch, Mr. O'Farrell. First of all, I don't know if this officer is qualified to say if they're opioids or something else. So I'll sustain the objection on relevance grounds. Even if they were opioids, I'm not quite sure how that plays into your theory you just indicated to the court.
In a portion of the statements that Lisa first gave back on the 30th of January, do you recall an indication to her that Jamel might have to be dragged into this for testifying about that?
Objection, hearsay.
Recollection of testimony, Judge.
I'll overrule the objection.
Do you recall her testifying about that?
Yes.
Do you recall her testifying about fear of Jamel?
Objection, Your Honor, the court already ruled that wasn't relevant.
I ruled it was relevant or irrelevant. What did you say?
Me, Your Honor?
Yes.
The court already ruled that any issue of Ms. Curtis's fear was not relevant.
I don't remember that ruling. So at this time, I'll overrule the objection. Continue.
What investigation have you done of Jamel?
Never had any contact with him.
Do you know who he is?
I do not.
You were not interested in the person who supplied the information to Lisa, identifying Tone as the shooter of her son,
I was not investigating that homicide.
but you were investigating the homicide of Tone, weren't you?
Correct.
Now, Davion came to the police headquarters with that interview with Lisa, didn't he?
Correct.
And they both came voluntarily.
Yes.
In fact, Lisa had been asked to bring him with her. Is that correct?
No.
That's not correct?
No.
At that time, from your canvass of the neighborhood and so forth, you had information that the shooter was wearing a mask, correct?
After speaking with one of the witnesses, yes.
Were you surprised when Davion walked in wearing a mask?
Yes, I was.
That mask was seized, wasn't it?
Correct.
So were the two masks that were found at his house?
Yes.
If I can have just a moment, Your Honor. I have no further questions, Judge. Perhaps I should seize or get back the Exhibit 1.
Okay, that's fine. Any other questions of this witness, Mr. Fedora?
Yes, Your Honor.
I do have a number of items to respond to. Sergeant, Mr. O'Farrell asked you about the phone number that Mr. Thompson gave you. Were you ever able to obtain the phone that Ms. Curtis identified as Brandon's phone that was given to Mr. Thompson? Were you ever able to retrieve that phone?
No.
And what was your understanding as far as what happened to the phone?
Objection, Judge. Foundation.
I'll overrule the objection. Proceed.
Sergeant, what was your understanding as far as what happened with the phone?
The defendant claimed that he lost it at the hospital.
Was there any other information you had as far as where the phone went?
No.
Now, with respect to sending the car to the crime lab, again, the defendant had admitted to driving the car, correct?
Yes, he did.
Well,
Did you have any other?
excuse me, admitted to driving the car, not at the time of the shooting. I want, to me, that's a confusing question, Judge. I object to its ambiguousness.
Rephrase the question, would you, Mr. Fedora?
Your Honor, the defendant in your interview admitted to driving the car at some point, correct?
Yes.
You didn't have any other suspects to compare any fingerprints inside the car at that time, correct?
Correct.
And even if someone else's fingerprints were inside the car, it wouldn't determine whether they were driving the car on January 27th, isn't that correct?
Correct. They would just be there. We would not be able to differentiate a date or time or anything of that nature.
Right. And then your information was that the shooter shot from the Charger, correct?
Yes.
So whether there's gunpowder inside the car, that wouldn't help you, would it, as far as determining who actually shot from the car, would it?
No, the gunpowder wouldn't tell us anything outside of what we already knew, that the shooter shot the victim from inside the vehicle. Each bullet does not have identifying gunpowder. Each casing does not have identifying gunpowder in it. So any type of residue that would be left over, whether it was from any firearm, we wouldn't be able to differentiate between any firearm that it came from to begin with, and it would serve no purpose in regards to when it actually was fired.
The phone records that you obtained regarding the phone that was associated with the defendant, you sent those to Detective Kahn, correct?
Yes.
And do you know if there was any information obtained as far as whether the phone was shut off or anything like that?
I don't recall.
Okay. That would be Detective Kahn who could testify to that?
Correct.
Now, Mr. O'Farrell referred to Brittany Ziem's testimony. Do you recall that?
Yes.
Now, when you contacted her initially, was that on January 27th, 2018?
Yeah, she was part of my initial neighborhood canvas.
Okay. So you talked to her then, today's, this is March 2021. So this is over 3 years later, correct?
Yes.
Your Honor, I'm going to object to this line of questioning because the witness, Ms. Zion, was not, there's no foundation for this as far as any statement that she had testified to.
I'm not even sure what the question is at this point, Mr. O'Farrell. I don't know what you're objecting to. We merely asked that he talked to the victim, the witness on the date of the incident. I don't know where he's going after that.
Okay.
And so Sergeant, it's typical in your experience as a police detective and a sergeant that people's memories will fade as time goes by.
Objection, Judge. That calls for a conclusion and really for an expert opinion. I'll stipulate that people's memories fade.
I was going to say mine fades, so I don't think that's really an issue.
Now, Mr. O'Farrell also asked you about the odor of marijuana inside the car. When did you conduct the search, the impound
I
search?
believe that was February 8th.
All right, February 8th. And Officer Hill found the vehicle on January 27th, 2018, is that correct?
Correct.
So well over a week later, you actually
Right.
searched it.
Yes.
The address that you searched, I believe, is on February 1st. Is that right?
Yes.
Okay. Was that address given by Mr. Thompson as his address?
Can I check my report quick?
That's fine. And I'm referring to his interview.
4781 South Washington Road. That's what he did.
And is that the address you searched?
Correct.
Now, I'm going to refer you to the text messages again. Mr. O'Farrell asked you a series of questions. So, first, I'm going to ask you in relation to the January 21st and 22nd text messages. In those messages, did the Antonio Parham phone, messages coming from that phone, did they provide a specific address as to the person, well, to the phone associated with the defendant? And I'm just talking about the 21st and 22nd.
Can you repeat that for me, please? I guess I didn't quite follow you.
In the text messages from January 21st and 22nd,
Okay.
did Antonio Parham's phone, was there a message sent to the number associated with the defendant that indicated the exact address of Parham? So did it indicate 522 Bond? Just the 21st and 22nd?
Not on either one of those days.
Okay. Is there an indication as far as the street name of where Parham was located, just for the January 21st and 22nd messages?
Yes. On the 22nd, January 22nd of 18, that message was sent to 989-475-4365 at 7:47 and 18 seconds in the morning in the AM. And the message reads, S. Bond, right by Mackinac. So South Bond, right by Mackinac.
And what does the message before that say?
The message right before it
Yeah.
says, ain't it?
Oh, I'm sorry. Just go another one back.
Says, man, I've been up for 2 days. Where you stay, that's over there by Lee Street.
Okay, thank you. And is there another reference to Bond Street just on those 2 days?
On those 2 days,
And that's fine. If you can't find it, I can move on to the next question. Sergeant, that's fine.
I don't see it.
On January 27th, so on those messages.
Okay.
So my understanding is the texter from the phone associated with the defendant, he's inquiring as to the address where Parham is. He's inquiring again as to where that address is.
Objection, Judge.
that
Again,
correct?
assumes the fact it's not in evidence. The person using the phone at that time is inquiring.
I think he said the phone associated with the defendant. I don't think he said the defendant was necessarily using the phone.
He used the word again, Judge, implying that it was tied to the first time.
Okay, sustain the objection. Rephrase the question.
So I'll ask the question again, Sergeant. So on the 27th, so January 27th, is there a message there where, or some messages where it appears that the number associated with the defendant is sending text messages inquiring as to where Parham lives in order to find out where to go?
Yes, there is. I just want to make sure I start at the beginning.
And you don't have to read them, but just generally, you're
Oh,
finding
yes,
that
there's-
content is there.
It looks like there's a couple times leading up to the actual address being given.
Okay. And that's my next question is, so on January 27th, Parham gives a specific address, correct?
Yes.
Okay. So from that, can you draw from that there wasn't a specific address given on the 21st and 22nd? So whoever was using that phone on the 21st and 22nd didn't have the address yet. He finally gets it on the 27th. Is that consistent?
Correct.
Okay, so that's consistent with the person who was using the phone associated with the defendant on the 21st and 22nd, that person being the same person who was using it on the 27th.
Correct.
Now, can we also assume that there's a possibility the defendant did know where Mr. Parham actually lived? Is that a possibility?
Yes.
Okay. And is it also possible that the defendant did not want Mr. Parham to know he
I'm
knew
going to
where
object
Mr.
to
Parham
what's
lived?
possible. We need to get facts, not what's possible.
I'll sustain the objection.
Is there anything else you can find that's consistent between the 21st and 22nd and then the 27th as to how the number associated with the defendant refers to Mr. Parham? Is there a name?
Just the terminology that was being used to, I guess, lack of a better word, to grief the person. Multiple times there was the word cuz, C-U-Z.
And that's on the 21st and 22nd, cuz was used?
On the 21st, it was used a couple of times. 22nd. It was used, it looks like 2 more times.
And then on the 27th, was there anything as far as how the phone associated with the defendant referred to Mr. Parham that's consistent with those other 2 days?
Using the word "cuz" again. Looks like multiple times.
And you're referring to the 27th?
Correct. Yeah, it was used multiple times in that conversation.
Mr. O'Farrell asked about the defendant's claims that he had been in bed for, I think it was a couple of days, I might be wrong, but he had been in bed prior to meeting with you at the department when he met with you on the 30th, and he discussed that with you.
Yes.
Right, okay. And then you also heard his doctor's testimony, and in that testimony, she indicated he actually walked out of the hospital, correct?
Yes.
She also indicated that his symptoms had improved, correct?
Yes.
Now, with respect to Mr. O'Farrell's inquiry as to, whether there was any investigation of Jamel, with the evidence that you had, that the defendant was the person who had killed Mr. Parham, was there any reason to look into this person who was just merely a source for Ms. Curtis?
None at all.
That's all I have, Your Honor.
Anything else, Mr. O'Farrell?
Just a couple. Hold me to that, Your Honor. You were asked by Mr. Fedoric if, and I think I can get this, if it would have been consistent in obtaining the address on the last call with the person who had made the first 2 calls not knowing exactly where Tone lived. Correct?
I wasn't following you. Can you repeat that? Because
I'll try.
I was,
I believe that the line of questioning was the obtaining of the address in the last call. For
The
Tone.
last
Texts?
Text.
Okay,
Yeah.
that's where I'm confused for a
Okay,
second.
I'm
Okay.
sorry.
no, you're fine.
Okay, the last text was consistent with the first 2 texts because they didn't obtain an exact address. In other words, the person still needed the address, is the consistency.
Right, up until the actual address was given, it was just South Bond and Mackinac.
Okay, so that would be consistent, but it directly contradicts the sworn testimony of Lisa that Tubbs knew already.
Objection, Your Honor.
What's the basis of your objection?
I guess I tried to get into that with Sergeant, and Mr. O'Farrell objected to that, so I would guess that it wouldn't be an admissible opinion.
I don't remember him objecting to that, and if you did, I'm overruling your objection at this point in time anyhow. Proceed.
That was my last question, Judge.
Oh, thank you. Call your next witness, Mr. Fedoruk. You may step down, Sergeant Jacobs.
People call Agent Nathan Satura.
Agent Tesoro, come down and be sworn by my clerk, please.
Good afternoon, Mr. Agent Satura. Could you please state your full name and spelling your first and last?
Nathan Satara, Nathan, S like Sam, Utara.
All right. And currently, you're a federal agent, correct?
Yes,
Okay. I'm going to just refer you back to January 27th, 2018. How were you employed at that time?
at that time I was a detective trooper with the Michigan State Police assigned to the major case unit here within Saginaw.
And on that date, January 27th, 2018, do you recall responding to a homicide scene?
Yes, I do.
And where was that?
It was 522 South Bond Street here within the city of Saginaw.
And do you recall approximately what time you arrived?
The homicide occurred at approximately 12:30. My partner and I arrived about an hour later, approximately 1:30 p.m.
And who was your partner?
Detective Trooper Bryant Greenert.
And what were the two of you assigned to do at the scene?
Officer Jacobs at the time told us that Saginaw was handling the homicide investigation, and they requested our assistance with processing the scene, collecting evidence, taking photographs.
Okay.
I'm just going to refer to you 35 and 36, People's Exhibit for Identification. Do you recognize those?
Yes, I do.
And what's 35?
35 is an overall shot of several placards where we collected evidence, including the house that the homicide occurred at.
And what's 36?
36 is a closer view of specifically the items that were marked as potential evidence.
Your Honor, I just want to check with the court reporter. Are 35 and 36 both admitted at this time? I just asked to publish 36 so that it can be referred to by Agent Satura.
That's fine.
Okay, Trooper, so I have up there, up on the screen, that's what's been admitted as People's Exhibit 36. Now, I'm first going to refer you to an item, a laser sight. Did you happen to locate that on the driveway?
Yes, we did.
Okay. Now, there's a laser pointer on the witness stand, if you can locate that.
Yes, sir.
And if you can you just point that at the picture of the driveway, indicating where roughly you found the laser sight?
This placard right here was where the laser sight was resting when we arrived at the scene.
Okay, thank you. And I'm just going to refer some photos to you. So exhibits previously admitted, 51 and 61 are in front of you. What is first People's Exhibit 61?
61 has our Michigan State Police evidence placard, letter B, as in boy, right next to the laser sight that we recovered.
Okay. And what is 51?
51 is just a closer shot of the laser sight without the evidence placard next to it.
Okay. And did you end up actually seizing that laser sight?
Yes, I did.
And are those two photos, 51 and 61, are those true and accurate representations of the laser sight as you saw them on the driveway?
Yes, they are.
People would offer into evidence what's been marked as people's 51 and 61.
My records show both have already been admitted.
Oh, I apologize, Your Honor. Now, when you collected the items, can you just describe how you handled the evidence?
Prior to touching any evidence, the first thing we do is put on gloves as to avoid any possible contamination onto the piece of item or the item or potential evidence.
Okay. And now when you apply the gloves to your hands, do you make sure that you don't touch the fingers of the hands?
Yes,
Okay. So any area you might be handling the evidence, you make sure that you don't touch, with the other hand, any part of that glove.
that is correct.
And did you do that in this case then?
Yes, we did, sir.
Okay. Now, when you collected the laser sight, so when you picked it up, obviously, did you pick it up with any part of the glove that you had actually touched?
No, sir. It was with my fingers that I do not touch whenever I'm donning the gloves, taking them on or putting them on.
Okay. Now, there's a kind of textured part of the laser sight. Do you notice that?
Yes, I do, sir.
Okay. And let me put that up a second.
The photo of it, yes.
So a little hard to see with the lighting, but nevertheless, could you just point to the textured area using the laser pointer?
Yes, the textured area would be right here.
All right. Now, did you ever, in handling that laser sight, did you wipe it off, or wipe it in any way?
No, sir.
Okay. Now, so you picked up the laser sight. What did you do with it after that?
We immediately put it into a manila envelope so that way it would later be sent to the lab for any possible testing for DNA or fingerprints.
Okay. Now, the defendant in this case, Davion Thompson, did you have any contact with him on January 27th, 2018?
No, sir.
Okay. And had you had any contact with him prior to that at any time?
Never.
So at the time you collected this laser sight, you had never had contact with Davion Thompson, correct?
That is correct.
And just to, and I'll ask, back in 2018, were troopers, detectives, were they wearing face masks when they were collecting evidence?
Not at that time, no.
Okay, now I'm going to refer to the other items that you found. As far as shell casings, were there any shell casings that you found along the driveway?
Yes, there were 3 shell casings that we located and ultimately seized as part of the investigation.
Okay, and if you can using, oh, no, you're not going to find it there. Just a second. If you can you just point to each shell, the location where you found each shell casing?
Yes, the first one that we located, we labeled as marker A. That shell casing was located right here. The next shell casing we located, we labeled as marker C, as in Charles. That was located right here. And the final shell casing that we located was D as in David, and that was located right there.
Agent Satara, do you recall what the weather was like that day?
It was sunny, but it was extremely windy.
Okay. Now, describe the shell casing as far as the shape of it.
It's shaped like a cylinder and it's fairly light.
Okay, so it could roll along the driveway, that's possible?
Yes, absolutely.
Okay. So as far as how, for instance, C got over to that part of the driveway, it could have rolled there, correct?
That is correct.
Now, and again, when you collected those items, were you wearing the gloves?
Yes, we were.
Okay. Now, and that was the same pair of gloves that you were wearing when you collected the laser sight, correct?
That is correct.
Okay. And do you recall if you collected other evidence prior to collecting the laser sight?
I do not recall which evidence we collected first versus last.
Okay. Now, what did you do with the shell casings you just referred to?
Each shell casing was put into a separate manila envelope, and they were all packaged within one larger envelope because they were going to be later taken to the lab for testing.
Now, my memory isn't totally working well today. Can you just give me the number, exhibit number of what I gave you?
Exhibit 20.
Okay, thank you. So if you take a look at exhibit 20, is there anything on that that indicates to you what's inside of it?
Yes, it was items that we labeled as A, D, and C, which were the shell casings that we collected.
Okay, and all right, and so from that, you know that the shell casings you collected are in exhibit 20.
Yes, they are.
Okay, I'd offer into evidence people's exhibit 20.
My record shows already been admitted.
Oh, yes, thank you. And were there other were there any fragments of bullets that you found on the driveway?
Yeah, there were two specific locations where we located brass or copper shell fragments.
Okay. And with the laser pointer, could you just point out where you found those?
Yes, we located one of those items right here. We labeled that F as in Frank. And the other one is way up by the house. We labeled that I as in Ida.
Okay. And were there any bullets that you found?
There was one bullet which we found it was lodged in the siding of the house. We were able to extract it and we ultimately recovered that and seized it as evidence.
Okay. And are you able to point out where that was located on people's 30?
Yes, it was in this photograph. That's me standing there. And just on the other side of me in the siding is where the bullet was recovered from.
Now, what did you do with all these items?
We packaged them. We took them back to the Saginaw Police Department where we sealed them with evidence tape and we turned them over to Saginaw Police Department for their investigation and to send to the lab for whatever analysis they deemed required in this case.
Okay, thank you. And what other than what I just mentioned, what else did you seize from the location? Collect from the location?
If I may refresh my memory, we seized the victim's black slippers, which were located there, a black hat. There was in the driveway a blood stain, and we took swabs of that blood. And then the shell casings and the laser sight.
Okay, thank you. Nothing further, Your Honor. Thank you.
Questions, Mr. O'Farrell?
Thank you, Your Honor. Did you get there, was the body already removed when you got there?
Correct. The body was not there when we arrived.
Okay. And did you see a blanket out there in the vicinity of the casings and so forth? Do you remember a blanket as an item of clothing or as just an item?
No, sir. As you see this picture right here, this is exactly how the scene looked when we arrived.
Do you know whether other police officers would have seized items before you got there?
That I do not know, sir.
Was it your understanding that your role was called in to process the evidence?
That is correct.
So with that being a call-in for you, wouldn't it be unusual for someone else then to be collecting evidence?
I suppose.
I have no further questions, Judge.
Anything else, Mr. Fedora?
Just real quick. Agent, do you recall Sergeant Volker being present?
There were several officers and sergeants there. I don't know who exactly was present at the scene.
Okay, but there were Saginaw Police Department officers were present.
Yes.
Okay, thank you. Nothing further.
You may step down. Thank you. Call your next witness, Mr. Fedora.
People call Nicole Graham.
Ms. Graham, you can come forward and be sworn by my clerk, please. You can have a seat.
Good afternoon, Ms. Graham.
Good afternoon.
Could you please spell your your full name for the record?
Sure, my name is Nicole Graham, and Nicolegraham.
And how are you employed?
I'm employed with the Michigan State Police at the Lansing Forensics Laboratory. I'm a forensic scientist and also a unit supervisor in the biology and DNA section.
And do you have any specific educational background that enables you to perform DNA testing?
I do have a Bachelor of Science degree in biochemistry from Alma College, and I've taken some graduate level coursework in forensic DNA.
And do you have experience, or actually how much experience do you have as far as DNA analysis?
I've been a forensic scientist for 23 years now. I started out with the Florida Department of Law Enforcement, where I worked for 2 years. I then worked for 8 years with the Virginia Department of Forensic Science, and I've been with the MSP for over 13 years now.
And are you proficiency tested?
Yes, twice a year.
Now, do you know the number of times or approximate number of times that you've been qualified as a DNA biology expert?
I did keep track, and I checked yesterday, and it was 119 times prior to today, and that's in Florida, Virginia, Michigan, as well as federal courts.
And with that, Your Honor, I'd move to qualify Ms. Graham as an expert in forensic DNA analysis.
Mr. O'Farrell,
I have no questions, Your Honor, and I would stipulate.
she will be so recognized.
Thank you, Your Honor. First, if you can explain to the jury, what is DNA?
DNA is a biological molecule that is found in most of the cells of your body. It is the genetic material that you inherit, half from your mother and half from your father. And DNA does code for things like what color eyes you have and how tall you become. But a lot of DNA is the same between all humans. It codes for the fact that we have 2 arms and 2 legs. There are some regions that differ between humans, and those are the areas that us forensic scientists look at in order to differentiate between biological material from different people.
And now, can a DNA sample be obtained from an object that someone touches with their hands?
Yes, years ago when forensic DNA first came around, you needed a blood stain or a semen stain that was kind of large. This was back in the late 80s and early 90s. Over the years, it's gotten far more sensitive. So gosh, for the last 15, 20 years, probably we've started noticing we could get DNA from touch DNA or contact, just an item that somebody handled or held or touched.
And is there anything more, I guess you could say, about how the DNA would transfer from the skin to the object?
Yes, it's actually, with COVID, it's almost better, I think easier for people to understand. We're all wearing masks. We've been wearing masks in the DNA laboratory for many, many years. Those tiny micro droplets of saliva that we think could carry viruses that could land on the surface or you could inhale, all of those contain human DNA from the person that it comes from also. So DNA can be spread by talking, coughing, it sheds skin cells, like if you scratch your head or had some dandruff, that could have DNA, or just sweaty hands, biting your nails. Any of those could leave DNA on surfaces that you touch, or even if you don't touch it, if you're just talking near it, some of your DNA could land on those items.
All right. Now, when law enforcement or someone from your office wants to collect DNA from an object, what exactly will they do?
Most touch DNA samples are collected through swabbing. Usually it's just a regular cotton tip swab, like a Q-tip, and they just moisten it with a little bit of water and then just rub the surface and try to collect as much of that area as they can and submit it to the laboratory.
All right. And then as part of your analysis, you'll compare that with a known sample from a human, is that correct?
Yes, in general, what we do is develop a profile from an evidentiary sample, an unknown, and then we also develop known DNA profiles from reference samples that are taken directly from a person, and then we can compare and see if they're the same or different.
And how would a sample be collected from a human?
It used to be blood samples, but that's pretty invasive. So normally nowadays we just get a buccal swab, which is kind of like a saliva sample, but they'll actually rub inside the cheek and try to collect some of those cells from inside the lining of the cheek. We can still use blood too, though.
Now, just going to ask you some questions about the testing procedure. Now, obviously, you're able to compare a sample obtained from, whatever object, and then compare it to a person's known human sample, correct?
Correct.
All right. Now, and then I'll first ask, does your testing follow standardized written procedures?
Yes, it does. We have a very extensive, detailed protocol that we must follow.
Okay. Now, so you have a swab where you've collected the DNA sample from either some object or the person. How do you get that DNA off of the swab so that you can analyze it?
Quickly, they just cut the swab and put it into a little tube. And then we add a series of chemicals that break open the cells and release the DNA. We perform some steps that purify that DNA and remove protein and other cellular debris so that we have just DNA. We do a quick quantification step that tells us, one, if it's human DNA and how much of it that we have. We then do a procedure called polymerase chain reaction, or PCR. And this is where we get our sensitivity from. It actually targets, in our case, we target 23 different regions on the human genome to copy many times over. It just mimics the same process your body does when it creates new DNA to make new cells. We do that in a tube. Once we've done the PCR and we have more DNA, it goes into an instrument called a genetic analyzer, where the DNA fragments are separated by size. The output of that is what we call an electropherogram, and it's basically a series of peaks. It'll kind of be a baseline, and then there'll be a peak wherever it sees a DNA fragment. And those peaks across the 23 different regions we're looking at form a pattern that we would term a DNA profile. That DNA profile can be compared to DNA profile of the known reference sample to see if they're the same or they differ.
Now, from that profile, can you determine how many contributors there were to that DNA sample?
Yeah, sometimes we get single source samples. That would usually be from something like blood, where it's just coming from one person, and those are very easy to interpret. But a lot of the times nowadays, especially when you're dealing with contact DNA, we're getting a mixture where we have multiple contributors, multiple people's DNA mixed in there together. Because you inherit half of your DNA from your mom and half from your dad, you generally have two types at each of those 23 regions. You'd see two peaks. Occasionally, your mom and dad happen to just give you the same type, so you'll have just one peak, but it'll be twice as big. Anyway, so a single source sample, you don't expect to see more than two peaks at each region. Once you start seeing 3 and 4, you know, oh, I have at least 2 people in here. Once you start seeing 5 and 6, oh, I must have at least 3 people in here. And if you get 7 and 8, now you're up to 4 contributors. Now in our laboratory, we do not interpret anything more than 4 contributors. So once we see a 9th or 10th allele indicating a 5th donor, then we say that it's too complex to interpret.
All right. And then is this interpretation or analysis as far as how many contributors there are, can that be done visually?
It is done visually, yes.
Okay. And as far as comparing then, and then the next step is you would move on to compare the profile to a known sample. Is that correct?
That's correct.
All right. Now, your lab wouldn't do that if there's more than 3 contributors. Is that right?
More than 4.
More than 4, sorry. So what is used to do the comparison between the known and the DNA sample from that object?
If it's single source, we can visually just look at them and see if the types are the same or different. And if they're different, then it's an exclusion. It's not that person. And if they're the same, then we have to assign a statistical probability to the weight of that match. This stems back from early on when they did ABO typing. You could say, oh, the blood match, they're both type O, but that's 45% of the population, so it's not very discriminating. So we're required in Michigan by law to provide a statistic that goes with that match. Now with a mixture, the process is similar, but it can get a lot more difficult. So we have a new software called StarMix. That's spelled STRMIX. And it actually performs what we call a mixture deconvolution, where it can kind of try to separate out the different contributors, what the most likely types are from the different contributors to a mixture. And this can help us with our comparison. The other thing that StarMix does for us is calculate a statistic to go with that, either match or inclusion of a profile.
And do you have a term you used for that statistic?
The statistic that we currently report using StarMix is known as a likelihood ratio. It is, you compare 2 different hypotheses. So the first hypothesis would be that the person of interest that you're comparing is a contributor, and then that's weighted against the hypothesis that they're not a contributor and it's someone else. The likelihood ratio, if it's a 0, that means they're excluded and they are not a contributor, they're outright excluded. If you get a likelihood ratio of 1, that means there's equal probability between the 2 hypotheses. It's just as likely they're in there as not, so that's basically like an inconclusive. We can't really tell. If you get a likelihood ratio greater than 1, that indicates support for the first hypothesis, that that person of interest is a contributor to that mixture. And the higher the number that goes, the more support that it gives to that. So to say a likelihood ratio of 100 is not very strong support that they're in there. And if you go up to 1 million or 1 trillion or 1 quintillion, that strength goes up. Now you can also get likelihood ratios that are less than 1, and those would lend support to hypotheses 2 being more likely to be correct. That they're not in there, it's someone other than them. They're not outright excluded, but it doesn't really look like they're in there. We don't get those quite as often, but that's another possibility.
Now, with respect to that StarMix software, is that something that's generally accepted in the scientific community?
Yes, it's gaining a lot of popularity. It's still fairly new. It was developed in 2012 in New Zealand. It's been used extensively in Australia and New Zealand since then. It then moved into America, Canada, and Europe. And I checked their website just the other day, and they said they've just had their 220,000th case using StarMix since 2012 worldwide. So it's become very popular. There's 59 labs in the US that are currently using it on casework, but there's another 50 to 60 that are in the process of validating it to go online with it.
Okay. Thank you, Ms. Graham. Now, did you receive any samples in this particular case?
I actually analyzed the data. The laboratory did receive samples.
And were there samples that the lab actually received related to this case?
Yes, there were.
And what were those?
There was two, one evidentiary sample, which was swabs of a laser site, and the other was a known from Davion Thompson.
Okay. And who were the samples received from, or where were the samples received from?
Well, the samples were submitted from Saginaw PD to our Bridgeport laboratory. A scientist there actually swabbed the laser site. She actually received the item and swabbed it in the laboratory and then forwarded that swab to the Lansing lab for DNA.
Okay. And someone else in the lab then does the extraction, runs it through the genetic analyzer, and then you receive the data. Is that correct?
Yes, in this case. We are all trained to do the lab work and the interpretation, but sometimes cases can switch hands. It's a kind of a matter of efficiency. So I'm trained to do the same things, but I did not perform the lab work in this particular case. I just received the data and did the interpretation and the star mix.
Okay. So all the testing steps, the testing procedure you just outlined, that was all followed in this case?
Yes, we're all required and we're all proficiency tested, but we're all required to follow those same written procedures.
Okay. Now, when you took a look at the data, were you able to determine whether the DNA sample from the gun site was suitable for comparison with Mr. Thompson's sample?
Yes, it was suitable.
And were you able to determine the number of contributors?
Yes, in this case, there were 6 alleles at a couple of the locations. So that indicates to me there's at least, that there's probably 3 contributors, and there was no indication that it was more than 3. In this case, there was sort of a major person, like a high level contributor, and then 2 very low level that were only partial. I didn't see their types at all of the regions.
Now, I'll get to the stir mix analysis in a minute, but with the profile that you saw, was that something that you could visually analyze yourself?
I would be able to, yes. And the major donor, it's our policy to mixtures to use star mix no matter what, but the major was obvious to me visually also.
Okay. And then you then ran the data that you had, you ran that into the star mix program, is that right?
Correct.
Okay. And were you able to reach a conclusion or get a result as far as the stir mix analysis?
I was. So the star mix did the deconvolution, and it gives you a mixture proportion. So it said that contributor 1 was about 93% of the mixture, and then contributor 2 was about 5%, and contributor 3 about 2%. So you can see that that lined up with my visual interpretation that I had 1 major contributor and 2 very minor. It then went ahead and what it does is it pulls out what it thinks the most likely explanation is for each of those contributors. So for contributor 1, it was able to pull out a complete profile and say, I think this is contributor 1's complete profile. I then ran it against Mr. Thompson's DNA, known reference sample that we had also developed a profile from, and it lines up with that contributor 1 profile. So it gave a very high likelihood ratio because it fit perfectly with that first contributor to the mixture. The likelihood ratio that we got in this was 1 octillion. An octillion is 27 zeros, just in case anyone doesn't know that.
Okay, and so just to clarify, so the Thompson sample was the 93% contributor, is that correct?
Correct.
All right. And so what's that, can you just state the likelihood ratio in, I guess, in total as far as what that 1 octillion means?
Yes, so my actual conclusion was, hypothesis 1 was that the mixture was a combination of Davion Thompson and 2 unknown individuals. Hypothesis 2 was that it was 3 unknown individuals. And then that likelihood ratio was that it's 1 octillion times more likely that it's Davion Thompson and 2 unknown individuals than 3 unknown individuals.
And from that, are you able to conclude as far as the strength of the support that the defendant is a contributor to the DNA profile?
Yes, we include a verbal equivalent scale in our report that gives numbers of limited support, moderate support, strong support, or very strong support. That's because this likelihood ratio, it's a little tricky. It's a unitless number. There's no unit to it that I can say what is a big number really. So I think in this report, it was over 10,000 we called very strong support. We've actually just recently, since this report's been written, we've increased that scale. We've gotten a little more conservative, and now we say anything over 1 million is very strong support. So obviously in this case, an octillion is more than 10,000 or 1 million. So it falls into the very strong support category pretty solidly.
And as far as, so you explained the strength of the results with respect to Mr. Thompson. So just to clarify, as far as determining, so hypothetically, if you have one contributor who had actually touched an object, these results wouldn't tell you the actual time, like when that contributor had touched an object, correct?
That's correct. Touch DNA is a little bit tricky because it can tell you pretty well who someone is, but not when the DNA got there or how it got there. So it's very stable for years. If an object is just left alone and it's not really further handled, your DNA can stay on there indefinitely. And it can vary. You could touch something and not leave your DNA. You could not touch something and possibly get your DNA on it through transfer. So it's kind of tricky to say anything definitively of how it got there.
Okay. So as far as the minor, would you call the other 2 contributors, 2 and 3, would you call them minor contributors?
I would.
All right. What could you say about those contributors as far as, possible scenarios of when they could have touched the gun site?
Well, the same kind of thing. So there are 2 other people on the evidence. There's no way to say for sure that the last person that touched it is the major. That's often the case, but that's not always the case. I researched a lot of articles preparing for this, and unfortunately, they're trying to do more and more studies on touch DNA and who leaves it and when, and there's just a lot of variables. So the example I like to give is if you just went to the bathroom, washed your hands really thoroughly, and you put hand sanitizer on, and you come in through that door and you open the doorknob, you're very unlikely to leave any DNA. Your hands are clean. But I always use examples. Say you're a nail biter, like I am sometimes, and you're chewing on your nails and you're leaving saliva, which is a highly concentrated source of DNA, and you grab that door handle, you're quite likely to leave your DNA. So it really just depends on, it also depends on the surface you're leaving it on. Textured surfaces, porous surfaces, they tend to hold on to DNA better than a smooth surface. So something like glass doesn't do well. This table's pretty smooth. I wouldn't probably easily leave a lot of DNA, but we get really good results off like gun grips or screwdriver handles where somebody was hanging onto it tightly, and with some friction rubbing on a textured area, it will leave behind a lot of DNA. So there's just a lot of factors that vary. And then there are some studies that kind of hypothesize that some people just seem to shed more DNA than others. And they don't know if that's a permanent condition, like if someone's just always a DNA shedder, or if it's temporary. Again, it might be because one's a nail biter and one's not or something, but it does tend to vary between individuals on how much DNA they leave on things.
Okay. And is there anything you can say about, potentially, we're talking about a gun site, Exhibit 15 is on the screen. I believe you've seen that before.
Yes, I've seen a picture.
Okay. And with respect to that, I mean, what people hypothetically could have touched that?
Well, I would say I didn't actually see the item or swab it. One of our scientists in Bridgeport did. She has in her notes, and I reviewed them before I came here, that she swabbed the textured area on what would be the right side of that photograph. This is generally what we do on these kind of items for two reasons. The textured areas are where we get the most DNA from, and conversely, the texture areas are very bad for fingerprints. They never are able to get usable fingerprints off those rough textured areas where they like the smooth surfaces. And the smooth surfaces don't work well for DNA, but work well for latent prints. So this item was going, I believe, to latent fingerprints after DNA. So she swabbed the textured areas.
Okay, so, and let's kind of try and get a little bit more specific. So let's just assume there's contributor one and that person had actually handled the object. The other two minor contributors at 3% and 2%. Do you have any examples of who reasonably could have handled the laser site?
Oh, well, I would say DNA is just everywhere. Most things are not sterilized. We've even found that there can be DNA from manufacturing plants. They don't actually sterilize items before they put them on store shelves. We've had actually some contamination of supplies from employees of the labs that make some of our supplies. So it could be from that, or it could be from somebody talking near something. If you weren't wearing, it's actually probably going to be better in 2020 and going forward. People are wearing masks, but any other time, if somebody's coughing, sneezing, talking near an item, just tiny droplets could land on that. It could be from someone who used it previously. It could be from someone who used it most recently, and they just didn't leave a lot of DNA because their hands were really clean or something. It really could be anyone that is. At any of those three contributors, there are multiple explanations for how they got there.
And then as far as what would be your opinion as far as that number one contributor, that 93% contributor, if you could make one?
Well, it is a fairly low level sample, but not super low. We actually go quite a bit lower. And they are a nice clear major at 93%. So they are more likely to have made direct contact with it, but it's not 100% conclusive. So you are more likely, I'm more likely if I touch this table to leave my DNA than if I shake your hand and then you touch the table for you to leave my DNA. It can happen though, but it's less likely the further you get out. So
now maybe just explain a bit of kind of going into that secondary transfer. What is secondary transfer?
So primary transfer is direct contact. It means my DNA is on there because I touched the item, I handled it, I was holding it, or even, I was right here and I talked over it and my DNA is on it. It was direct, close contact. Secondary transfer would be when some other vector was used to transfer your DNA to an item that you didn't have direct contact with. Years and years ago, when we had, a blood stain the size of a quarter, they said, secondary transfer is impossible. That could never happen. We would have testified to that 20, 25 years ago. But as the testing got more sensitive, it became possible. So that's kind of the double-edged sword to the high sensitivity we have now with the contact DNA. We can get DNA we didn't detect before, but now there is a possibility of secondary, even tertiary transfer. But obviously, as you get less direct, it becomes somewhat less likely.
Okay, so there could be contact between one person, person A, they touch person B touches the object. There is a possibility that person A can get, person A's DNA can be found on that object. Is that reasonable?
That's correct.
Okay. And is there anything you can say about that? Any studies you've seen as far as any additional information on that?
Well, it's hard to quantify, and that's kind of hard for us as DNA people. We've always been very proud of being able to give that statistic. I gave you that likelihood ratio of an octillion, but that is only the likelihood ratio of his DNA being in that mixture. It has nothing to do with a likelihood of him touching it or having used it or committed a crime or any of that. Those would take additional information that we don't have. So most of these studies I read talk about how we need to do more studies, and they're talking about building data banks of statistics for how often you transfer your DNA and how often when you touch this item, it'll leave this much DNA. We're a long ways from that. So I don't have any hard and fast number that I can give to the likelihood. I reviewed a number of papers and several that summarized other papers. All of them agreed that it's more likely to have primary transfer than secondary transfer. Obviously, secondary transfer is more common than tertiary transfer. It kind of varied. There was one study they were saying that they washed their hands, then they put on gloves for like 2 hours so they get nice and sweaty in there, and then they made them shake hands for 2 minutes, which is kind of unrealistic. I don't know anyone who shakes hands vigorously for 2 minutes. And they said about 25% of the time in that study, they detected only the person who didn't actually touch the item. About 75%, they got a mixture or just the person who actually directly touched the item. Then another study, they did a similar thing, but they did 10 seconds of hands shaking. And in that case, they didn't detect anyone. They detected secondary transfer, but he was always the very minor donor. It was never the major. There was another part that they said they summarized like 6 different studies that said that in total in these 6 studies, less than 3% of the time was secondary transfer the major contributor to the mixture. So it's not impossible, but it is less likely.
Now, when you do get in that example, so person A to person B, with respect to person B's DNA, is that going to get on the object too? Is that kind of reasonable to assume?
Usually. So that'd be the most common is if I shake your hand and you transfer my DNA, you're transferring your DNA with it. And most of those studies said usually they had more DNA from the direct transfer person than the indirect transfer person. But not 100% of the time. There were incidences where they only detected the indirect person and not the person who did the transferring. And again, that could have to do with, say that the intermediary person has really clean hands, he just washed them, and person A has just been biting their nails and leaving more DNA. So it is possible.
Okay, and so let me kind of ask you about, so an officer who is handling the evidence, what are some possibilities as far as, even though if they're taking the precautions necessary, that their DNA could get on an object?
We try to train officers. We have people that go to crime scenes. The biggest thing is probably should be wearing a mask, or at least not talking over the evidence, because you could leave your DNA that way, and wearing gloves. And they're very good at wearing gloves, but I don't know that all of them maybe change their gloves between every item they touch. In the lab, we know how sensitive it is. We change gloves just constantly. So I think one of the biggest risks is they're wearing their gloves. They're worried about, they don't want to get their DNA on the item. But what if they touched something bloody from the victim and now they touched a different item? They could be transferring some of that blood DNA onto the other item.
Okay. And then I think you mentioned wearing masks, officers wearing masks when they're collecting evidence.
Yeah, like I said, that's been our requirement. As much as they're annoying and they fog up your glasses and everything, we've been required to do that in the DNA lab for a very long time, because we realized how much of a source of contamination, just even breathing. I mean, honestly, it's not even just talking. You can be careful not to do that. Sometimes you can't control a cough or a sneeze, and even sometimes just breathing.
Okay. So back in 2018, I mean, now officers are all wearing masks, right? Back in 2018, it wasn't as common when they were collecting evidence.
Probably not, no.
Okay. And so an officer talking, saliva could get on the object, as you're saying, and so the DNA from the officer could get on it?
Yes, I mean, any other DNA on the item could be, like I said, from the manufacturer, from anyone who's ever used it, been near it, handled it in the interim, from the officer at collection. Even in the laboratory, we take extensive precautions in the laboratory to avoid contamination, but it still doesn't mean it's completely impossible. We're still humans and we have DNA, so.
Okay. And then someone, obviously, a gun site, it's going to be sold at some point to some person. Is it possible that the person who sold it, assuming it wasn't packaged or something like that, that could be someone who gets their DNA on?
I was gonna say, I would guess they come in a box, but yeah, I don't know. Anyone who's come in contact with it, however long it's been in existence, could have left their DNA. And like I said, it can last, it's a very stable molecule. It'll last indefinitely on a surface if it's not subjected to high heat, humidity, direct sunlight, and it's not wiped away, it will stay on there.
Okay. So basically, this kind of highlights that we only have 3 actual contributors on this particular item where, you know, when there's so many people that could have come in contact with it. So is that significant?
It's really nice. We actually kind of officially refer to these as nice mixtures when you have only 3 and it's a clear major like that, because we get a lot of 4-person mixtures that may be a 25 to 25 to 25 to 25, and those get tricky because you can't tell which ones pair together because everything's the same height. This wasn't low level. I wasn't seeing extensive dropout. It was a nice mixture. As far as could there have been other people's DNA on it over the years? Yeah, and it could have been removed. That's another thing that can happen with touch DNA is that when you're touching something and leaving your DNA, you can also be removing the DNA from someone who touched it previously.
And now, and just to be clear, and I think you have been clear, just because someone's DNA or someone's DNA is consistent with being on the object, that's not 100%. In your Sturmax analysis, you have to consider other things with that to corroborate the fact that that person actually handled it, correct?
Right. I mean, the Sturmax is not making any judgment onto how anything got there, how long it's been there. It's only looking at the probability of that DNA profile existing, giving this person as a contributor versus not. So that's why, like I said, it gets tricky testifying to these because I can't give a similar likelihood ratio to say the likelihood of, okay, it looks very strong that his DNA is on there, but how did it get there? I don't have any way to give a firm number to that.
Okay. And with all that in, let me ask you just to kind of close. So considering the likelihood in this case, is that likelihood ratio in this case consistent with an argument that Mr. Thompson never touched the laser site that's shown up on the screen? Is the likely ratio consistent with a theory that Thompson never touched the gun site?
Well, the likelihood ratio is very strong support that it's his DNA on the gun. Again, it doesn't really factor in the likelihood of him touching it. Now, from my experience and the articles I was reading and research, the most likely explanation of his DNA being on there would be because he handled it directly. It's not the only explanation, but it would be the most common or most likely explanation to be a major donor on there.
Okay. Thank you, Dr. or Ms. Graham.
Mr. O'Farrell, I don't want to put you on the spot. How long you think you'll be? We can take a break if you're going to be longer than 15 minutes. And if you are, that's fine, but we'll take a break. I need a break. I'm sure other people may need one as well.
I'll defer to the court, Judge.
We'll take a short recess, ladies and gentlemen. Go to my clerk, please. You may be seated. The records reflect the jury is not present at this time. Anything for the record, Mr. Fedoric?
No, Your Honor.
Mr. O'Farrell?
No, Your Honor.
And Mr. Fedoric, after this witness, how many more do you intend to produce today?
2 witnesses before I rest.
Okay, and are they both present?
Yes.
All right.
Oh, let me correct myself. I believe the last text I got from Mr. Khan was 3 p.m. and he said he was on his way. He was half an hour away, so I imagine he's here.
All right. And so we get to those 2 witnesses today, you intend to rest, is that correct?
Correct.
Judge Khan is gonna take a while. It's gonna be a long day to try to get through him too. He's an expert on the phones, but you know how long Khan takes. I don't
Okay.
want to go that late, Judge, myself. I'm tired.
What do you mean you're tired?
Just what I said. That much I do know.
I'm tired of Rod. I'm kidding. I'm kidding.
No.
I love Rod.
I
Great
agree
guy.
with you on that point. Let's take a break and we'll